I'm Don Klawiter of Mayer Brown LLP, and I'm here today to interview Bruce B. Wilson, who was Deputy Assistant Attorney General during the Nixon administration. Bruce, why don't we start by telling us a little bit about your school background?
Well, Don, I graduated from Princeton's Woodrow Wilson School of Public and International Affairs way back in 1958, and then went to Penn Law School. And when I graduated from law school, I spent a year clerking for Judge Herbert Goodrich on the Third Circuit Court of Appeals. And following that, I joined a Philadelphia law firm, Montgomery, McCracken, Walker and Rhodes, and spent about 6.5 years with them.
How did you come to become an antitrust lawyer?
Well, in a sort of strange way. When I graduated from law school, the two things that I was convinced I did not want to do were antitrust law and railroad law. And that may sound strange for somebody who spent about 10 years enforcing the antitrust laws and 5 years defending people against them, and then spent 20 years as general counsel in the railroad industry. But I was doing my first love, which was litigation, for Montgomery McCracken, and along came the civil cases that followed on the electrical equipment indictments back in the 60s. And that dragged just about everybody who had any litigation experience at all into the courtroom. And after that episode, I decided, well, antitrust was pretty interesting after all. And so I did some more of it and a lot of patent antitrust work. And when Nixon was elected in 1968, I thought perhaps this was as good a chance as I would ever have, since I was a Republican, to get a responsible job in the antitrust division. So I sent my resume to Dick Mcclaren, who was going to be the Assistant Attorney General. We had an interview, and he hired me as his special assistant.
Just to follow out your career path after that, what other positions did you have at the division, and where did you go from there?
In December of 1970, I sort of took a 6-month detour and spent 6 months setting up the Consumer Affairs section in the Department of Justice, which pulled together all of the department's consumer protection functions. And then I became a Deputy Assistant Attorney General, I think in June of 1971, and Chief Deputy when Dick Mcclaren left in February of 1972.
And how long did you stay with the Antitrust Division?
I was with the Antitrust Division until 1979. I was the deputy until 1976, and then I went home to Philadelphia.
After you left the division, what did you do next?
Ron Dietrich, who had been general counsel of the FTC when I was deputy, was the first general counsel of Consolidated Rail Corporation, which was the government-owned agglomeration of all the bankrupt Eastern railroads. And Ron called me and said, how would you like to go to work for Conrail? And I thought that would be a nice transition back to the private sector. And I stayed at Conrail for 18 years.
So you became the railroad lawyer you would never become?
The railroad lawyer I would never become after I became the antitrust lawyer I would never become.
Tell us a little bit about Dick Mcclaren. He is an important figure in antitrust history, but because of the circumstances of his shortened life, when he died at a relatively young age, we haven't had the advantage of really having him be part of this series. So give us a little background on Mcclaren.
Dick Mcclaren was one of the world's great gentlemen. In addition to that, he was a very smart and successful antitrust lawyer. He had been with Chadwell, Keck, Kaiser, Ruggles, and Mcclaren in Chicago. He was head of the ABA's antitrust section in the year immediately preceding his appointment as Assistant Attorney General, while one could wonder about some of the heads of the various divisions at Justice, there was never any question about Dick's qualifications to be Assistant Attorney General. He came to the division with a number of priorities. One was to see if we couldn't do something about systematic reciprocity. You buy from me if I buy from you, which the economists said didn't exist because it shouldn't exist, and those of us who'd seen it work in the business world knew it did exist, and it had the effect of foreclosing smaller single-line firms from competing on a level playing field.
So this was the era of conglomerate mergers.
That was the second priority, was conglomerate mergers and to do something about them, and that probably was the priority that took up most of our time. And the third priority was to do something about enforcing Section 1 in the service industries, real estate boards, and ultimately medical boards and bar associations.
Tell us a little bit about the conglomerate merger, the reciprocity and conglomerate merger phase, which I think is something nowadays that people will look back on and wonder when that all happened in the antitrust world.
Well, not only when it happened, but why it happened. Back in the late 60s, the division had been quite successful against horizontal mergers and vertical mergers. And there came a wave of very large, for that time, very large mergers, in many cases between very large firms like ITT or Gulf and Western or LTV. Very large firms, and in many cases acquiring leading firms in concentrated industries. I remember being on the train and going down to start with the Antitrust Division in 1969 and reading in Time magazine a great lament about these very large mergers that were taking place, and why couldn't we do something about this? Well, we thought we could, and the theories were that these mergers enhanced the opportunity for reciprocity. In the case of a leading firm, that it entrenched the leading firm in its position by having access to the resources of the very large acquiring firm, thereby raising barriers to entry. That it eliminated potential competition between the very large firm and the leading firm. Some accused us of coming up with a self-proving theory, because the way we showed the interest of the large firm in coming into this industry was its acquisition. That wasn't entirely true, but I suppose it made a great jury argument. Those were really the theories behind the conglomerate merger cases. We filed 6 of them against LTV's acquisition of Jones & Laughlin Steel, Gulf and Western's acquisition of Goodrich Tire, White Consolidated's acquisition of White Motor Company, and 3 cases against ITT involving their acquisitions of Avis, Grinnell, and a Hartford insurance company.
How'd you do?
I think it's safe to say we didn't do well. We went for a preliminary injunction in all of those cases. Dick Mcclaren thought it was important, rather than to have these cases hanging around, to put on our best case on the preliminary injunction stage. And we won one. We won an injunction in White Motor and White Consolidated. We lost the injunction proceeding in all the other 5. So we were batting 167, which isn't a good average for in any league. I suppose that really set the stage for what happened with ITT and occupied a lot of our time for a substantial portion of the rest of my tenure at the department.
Could you tell us a little bit about that? This is the Dita Beard issue?
Well, it really all started back when we were appealing the denial of a preliminary injunction in ITT Grinnell. Mm-hmm. And in those days, we had the Expediting Act. Antitrust cases went directly to the Supreme Court without stopping at the Court of Appeals. So we were appealing the denial of the preliminary injunction to the Supreme Court and going to test our theories that way. We had prepared a brief in Grinnell in the Supreme Court, and were prepared to file it in April of 1971. This I all learned later. Apparently, President Nixon had called the Attorney General. The acting Attorney General was Dick Kleindienst. John Mitchell was disqualified in the ITT cases by reason of his prior representation of ITT, I believe. So Kleindienst was acting, and the President had called Kleindienst and apparently said, hold up on the filing of the brief. Don't file it. Matter of fact, I think he said. There's a quote in one of the Nixon tapes where the President said, that son of an expletive deleted, Mcclaren, I want him out, and I want him out within the hour. Well, that didn't happen. Kleindienst and Mcclaren went to see the Solicitor General, who was Dean Griswold, and asked him to get a second extension. We'd already had one. Dean Griswold was not happy because the Supreme Court doesn't usually grant second extensions, but he went and got it anyhow. The brief was filed 1 month later with one change. Instead of saying April 1971, it said May of 1971. And again, this is something I learned later. What happened in the meantime was John Mitchell had gone to the President and told him to keep his hands off the Antitrust Division. I learned that in the course of the later ITT investigation. Mitchell was a good friend of the Antitrust Division. I can't think of a single thing that we proposed to do that he turned down, and he backed us up on a lot of things.
One of the other features of this period of time is somewhat later than that was the Saturday Night Massacre.
Well, before we get to the Saturday Night Massacre, we come to the Dita Beard memorandum.
Go to Dita Beard first, that's for sure.
And that was during Kleindienst's confirmation hearings, after he had been nominated to be Attorney General upon the departure of Mitchell in March of '72 to head the Nixon re-election campaign. And Jack Anderson got a hold of a memo from an internal ITT memo from a lady by the name of Dita Beard, which said that our contribution to the $400,000 to the San Diego Republican Convention was instrumental in getting the settlement, which had taken place almost a year earlier. That settlement itself, that was one thing that I was present for. And it was in one of the last 2 days of July of '71. It was a Saturday. Either Ray Carlson or Joe Widmore, who were the lead trial attorneys on 2 of the Hartford or the ITT cases, was present. I was present. Dick Mcclaren was present. And we had a negotiating session with Henry Saylor, representing ITT. The result of that was that ITT agreed to divest Avis, Grinnell, some other companies that they owned, which could have had, where their continued ownership could have had the effect of directing business to Hartford. This was all in exchange for them getting to keep Hartford. The total divestiture was $1 billion, which in 1971 was a lot of money. I know today, where we're bailing out companies with 175 billion, it sounds pretty puny. But in 1971, it was a lot of money. And for a division that had won one and lost five, we thought this settlement established a pretty good deterrent against future conglomerate mergers. And I remember going down to the Department of Justice garage after we reached this agreement, and Dick Mcclaren was leaning on one of his children's cars, which had a big white stripe painted down the middle of the hood, racing stripe. And he said, "Do you think we did the right thing?" And I said, "Dick, $1 billion is a pretty good deterrent." And I still think that. It was a good settlement. However, all this became part of the Watergate investigation, and was being investigated by Archibald Cox in the Special Prosecutor's Office, and that had a pretty disruptive and demoralizing effect on the entire division, I think, and on me personally.
You understand that very well.
It ended up with only one charge, and that charge was against Kleindienst, and it was for failure to testify fully before the Congress. And what he left out was the phone call from the president, which really had no effect on the filing of the appeal, ultimately. So it was all a very interesting time at Justice.
What about the Saturday Night Massacre? Is that is next chronologically?
That's next chronologically, and I wasn't there for that. I was in Lausanne, Switzerland, between the OECD meetings and a speech which I had to give on the Monday or Tuesday of the next week in Zurich. And it was a late Sunday afternoon, and I got a call from Don Klawiter, who was the Assistant Attorney General. And he said, "Have you heard the news?" And I said, "What news?" And he said, "About the department." And I said, "Well, I saw Elliot Richardson put his reorganization plan into effect last Thursday." There was a little squib in the International Trib. He said, "You don't know how we've reorganized. The Attorney General's been fired, his deputy has resigned, the special prosecutor has been fired, and his office has been disbanded." And I said, "I quit." And he said, "Don't be hasty," and I know he has been interviewed for this series before and talked about the meeting that he held in his office that morning with the section chiefs, and all of whom said if he quit, they would quit. And that was my feeling too, and if he was going to stick, I was going to stick. So that's how all that turned out.
And what effect did that ultimately have on the running of the division? Was it also disruptive like ITT, or what was your sense of that?
Well, that was, after Archibald Cox was fired, Leon Jaworski, of course, took over as special prosecutor, so there really wasn't much of a hiatus in the special prosecutor's investigation of what went on in ITT.
Looking to some of the other things the division was doing during your tenure, the patent area seemed to be of some interest and some significance. Can you tell us what you and Dick Mcclaren were doing in that area that was significant?
Well, we had always when we got there was a section of the division dealing with patents and other intellectual property. A fellow by the name of Dick Stern was the chief of that section, and I think it's safe to say that Dick's reputation with the patent bar was sort of some sort of terror from places unknown. But I mentioned earlier that I had spent some time in doing patent antitrust work in private practice. And as we looked over the range of licensing practices, many of which still exist, it seemed to us that there were a list of ones that were particularly dangerous, that in our view almost always constituted misuse of the patent, thereby rendering it unenforceable. And if the requisite anti-competitive effect was present, could very well rise to the height of an antitrust violation. All that anti-competitive effect was to be judged as it is now, I think, under a rule of reason test. But the patent bar took this list of practices, which I put in a speech that I gave out in Pittsburgh to the Pittsburgh Patent Law Association, and it became known as the 9 no-nos. Probably the most cited piece of work that I've ever done. Not always, not now, and very seldom, at least in works by the patent bar, cited with approval. And that generated a big legislative fight because the patent bar came up with something which became known as the Scott Amendments to the Patent Code, which would have rendered most of these practices per se legal. And we had a large fight about that. It was a fight in which I would add John Mitchell backed us up. One time I think the amendments were getting dangerously close to clearing a congressional committee with the support of the Commerce Department. And I think Tom Kuiper must have been away because I was the acting assistant attorney general, and I wrote Mr. Mitchell a memorandum that was captioned 3 things on which I need help, one of which was the Scott Amendments, and the other 2 I can't recall now. But I sent that memo up, about a half an hour later the phone rang, and he said, "Come on up here." So I went up. He said, "Tell me a little bit more about this patent stuff." So I went over it. He picked up the phone, he called Maurice Stans and told him to lay off. And he did basically the same thing with the other 2 items, which I can't recall now. But as I said, for all of his other faults, which became apparent later on, not backing up the Antitrust Division was not one of those faults.
And Senator Scott was Senator Hugh Scott from Pennsylvania?
Senator Hugh Scott from Pennsylvania, and I had some interesting conversations with my own senator about that.
And he is also the Scott of Hart-Scott-Rodino.
He's the same one. Actually, our legislative relations, by and large, were really quite good in those days, compared to what I understand goes on in Washington now.
You actually talk to the senators
we
and
actually,
congressmen?
as a Republican administration, we actually talked to Democrats, yes.
Tell us about that.
About once a month or so. A couple of us, sometimes the Assistant Attorney General at that time, some of us, sometimes it was one of the special assistants, or I did it quite frequently. We'd go out and we'd have lunch with Senator Hart and his general counsel. Started off as Jerry Cohen, and later became Buck O'Leary. And we'd go over what legislation was pending, and we talk about antitrust policy, and we talk about it in a rational manner. And Philip Hart has always been one of the great figures in my life. I think he was a great gentleman and an excellent senator, and a thoughtful person.
In the legislative area, what other kinds of issues did the Antitrust Division focus on during that period of time? Well,
it may seem ridiculous now, but when I joined the Antitrust Division in 1969, a violation of the Section 1 of the Sherman Act, a big price-fixing conspiracy, was a misdemeanor for which you could be fined the princely sum of $10,000, or if you were an individual, spend 1 year in jail. we wanted to increase those penalties. And we finally got that increase in connection with, really after the Kleindienst confirmation hearing, Senator Tunney introduced a bill which resulted in the requirement that the division lodge proposed consent decrees with the court for a period of 30 days and file a competitive impact statement together with the proposed decree and make that available for public comment for a period before the decree would finally be entered. We tacked onto that the increase in Sherman Act penalties, which made it a felony, and increased the fine to, I believe, $1 million at that point. Since then, we're up to 10 years and $100 million, or if you go under the alternative sentencing provisions, substantially more than $100 million. So things have changed quite a bit in 40 years since I first joined the division.
Although during your tenure, there was also the first major effort to get prison sentences for individuals convicted of Sherman Act violations.
Yes, we as the deputy, I was sort of principally in charge of shepherding criminal prosecutions as they progressed, and we had a meeting after the amendment making it a felony, and I said, "Look, boys, it's a felony now. We are going to recommend jail in every case of price fixing." And everybody some sort of reluctantly said, "Well, okay." And so, of course, the first one that came down the pike was a gentleman about 79 years old with a bad heart condition. And the director of operations came in and he said, "What are you going to do now, boss?" And I said, 1 week, which, of course, he didn't get. But we recommended jail for every price fix after that.
You mentioned the professions in various cases, litigation on behalf of the division involving lawyers, doctors,
real estate
boards.
Yes.
Back to that again, it seems. Tell us a little bit about that.
Well, the real estate board cases were really the first ones that we started, and 40 years later, I note we are still arguing about various practices in the real estate industry, but compared to what was going on 40 years ago, I mean, there was a mandatory 6% commission, and if you varied from that, you got thrown out of the multiple listing service, and you really couldn't do business as a real estate broker. And so we filed a number of cases against practices like that. Eventually, and I'm not sure when, the division filed a criminal case against a real estate board. That practice bore a close relationship to what was going on in some of the bar associations at that point. They had minimum fee schedules, and they had committees that would discuss and establish these minimum fee schedules. And in most codes of ethics, there was a provision that said frequent deviation from the minimum fee schedule would be evidence of unethical conduct or unprofessional conduct. And the first go at the bar associations was a speech that I made in March of, I think, 72 to my home state bar association, in which I basically said that this was a violation of Section 1 of the Sherman Act, and that the unethical part was not deviation from the minimum fee schedule, but having a minimum fee schedule at all. And when I got done speaking to this room in Hershey, Pennsylvania, there was dead silence. And a friend of mine from the Philadelphia bar stood up, a fellow by the name of Harold Kramer, and Harold said, "He's absolutely right. These things are a disgrace to the profession." He was my friend for life after that.
During that speech, as I recall, you quoted from St. Matthew that a prophet is without honor in his native land.
In that case, he certainly was.
Quite a moment. going back home.
It was an interesting moment. I mean, I'm fond of saying, although it's not entirely true, that my wife had the motor running in the car outside.
It was probably somewhat close to that.
It was close to that.
The big cases were developing within the division during your time, IBM and I guess the beginnings of AT&T. Did you have a role in working on either or both of those cases?
Well, the only time I touched the AT&T case was when L. Patrick Gray became acting Deputy Attorney General after Kleindienst had become Attorney General. And Gray made his sort of introduction to that role was to take the assistant attorneys general and their deputies out to lunch, one-on-one. And Gray and I went over to Hamels one day, and he said, "What do you think are the biggest antitrust problems around?" I said, I thought a minute. I said, "Well, I really don't think AT&T needs to own the regional operating companies or Western Electric anymore. We'd been having a round that started at the FCC with Carter Phone back in the late 60s, and it was becoming harder and harder to regulate the telephone industry because you had MCI and some other long-distance services coming in. And Gray said, "Well, why don't you do something about it?" And I said, "Well, the division has had sort of a draft complaint kicking around for some time." He said, "Dust it off and look at it and send it up." So I went back and I called Bernie Hollander, who had been involved in that at that point, and related the conversation. I did a memorandum to Kleindienst because my wife owned a few shares of AT&T. And in addition, my dad worked for Bell, Pennsylvania. And I disclosed these two items and asked to be able to continue on the case, and came back denied. So that was the end of my involvement with AT&T. IBM was much more substantial. After the ITT settlement, we took much of the staff, at least the heads of the staff, Ray Carlson, Joe Widmar, and put them to work on a trial team which eventually totaled about 40 people and was headquartered up in New York when the trial actually got started before Judge Edelstein. And looking after that office and keeping its needs satisfied, and I fell to the deputy. We eventually had a conference call at 8 o'clock every morning. Sometimes lasted about an hour, sometimes shorter, sometimes longer, as to what happened the day before in the trial, what they needed, what we needed to have additional research done on in Washington, and so forth. So that really became a time-consuming operation, not only for the division, but for me as well.
And the trial dragged on for
on and on and on. Eventually, of course, the technology passed the point, and the technology was what really evaporated IBM's monopoly, and eventually the case was dismissed by Bill Baxter in 1981, I believe, the same day as the AT&T settlement was announced. So it dragged on well past my tenure at the division, but also well past IBM's actual ability to maintain its monopoly. But I think the pendency of the case probably had an inhibiting effect on some of IBM's more aggressive tendencies to maintain its monopoly in large-scale computers. Of course, the distributed computing that we all use today was just eclipsed them.
Exactly. During your time at the division, economics became much more important than it had been in the past, and I think for the first time there was the actual formulation of an economic policy office.
That's right. There had always been a practice of hiring for 1 or 2 years a well-known economist. George Eads was the special assistant for economics at one point. And when George Hay took that position under Tom Klawiter, there was a refocusing on economics and the importance of economics and antitrust analysis. And that led to the formation of the Economic Policy Office, and eventually the head of that office became a Deputy Assistant Attorney General. So it was really a refocusing of effort on economics in support of antitrust enforcement.
Just to complete the chronology of your time in the front office, Dick Mcclaren became a federal judge at a certain point in time.
Dick Mcclaren was sworn in as a federal judge in, I believe, February of 1972.
And who succeeded him as head of
Brock
the division?
Comegys took over as acting Assistant Attorney General. And Tom Klawiter, I think, took office, I'm going to say August 1 of 72. I'm not sure. It was either July or August of 72.
Well, we've interviewed Tom Klawiter for this series, but kind of give us your impressions of that period of time and that work. How was Tom as an antitrust division head?
Tom was a great boss. It was really a joy working for him. And he comes off as a very cool, steady person, which basically he is. But he can get riled at a couple of things. One of them is a wonderful story that he tells on himself, that he was washing windows back in Ann Arbor during an Ohio State-Michigan football game. And he's sitting on the windowsill with the window there, and Ohio State scores a touchdown, and he put his fist through the window. But
hard to imagine knowing Tom.
Yep. But he told that story on himself. So, but everybody that I worked for at the division was a joy to work for.
And Brock Comegys was acting for, I think, a significant period of time.
Well, Brock was acting from February until July or August, when Tom came and took over, and that, of course, was the whole period of the Kleindienst confirmation hearings, which Brock tended to stay away from and say, "Here, you do this."
Yep, exactly. Well, the division has certainly changed over 40 years, and I'd like to just get your impressions or your thoughts on ways in which it's changed for good or for bad, and just give me a sense of your view of the division today or of antitrust enforcement over the last, I guess, literally 40 years.
Well, we've already talked about one change, and that is the increase in criminal penalties, which obviously has had, I think, a real deterrent effect in the business world. We have a long way to go yet, but the possibility of 10 years in jail and an average of close to 3 years now for convicted individual price fixers is I think, a real deterrent. Any kind of jail for a businessman, I think, is a real deterrent. I think the increase in the size of the fines is a very major corporate deterrent. So we used to say back in 1969 that the private bar and its compliance efforts was one of our biggest assistance in enforcing the antitrust laws, and I think that's even more so today. Secondly, the importance of economic analysis has certainly increased. You can't sell a court anymore on I don't know what I should call it, the political economics theories of some of the conglomerate cases.
Right.
Although I detect in today's environment, with the too big to fail discussions that are going on here in 2009, that some of that may be coming back into play, at least in the political arena. And it'll be interesting to see how that works out, if at all, in antitrust and competition policy. Third, I really think that that there is a good deal more clarity in antitrust policy and antitrust enforcement than there used to be. I mean, the merger guidelines, which were first put out under Don Turner, who was Mcclaren's immediate predecessor. Under Turner and Zimmerman.
Right.
Were fairly new in 1969, and now they're in their third or fourth iteration. And we have a lot more experience and a lot more economic analysis that goes into those. Those, I think, are the major changes. I mean, antitrust still goes after, the generic enforcement of price fixing, and you don't see a whole lot of horizontal mergers anymore. But price fixing and cartel enforcement, certainly cartel enforcement, has reached a level that I don't think we ever dreamed of in 1969.
What about the international side of things? You obviously went to the OECD. There was some movement in the international spectrum during your time, but nowadays I think we're at a totally different order of magnitude.
I think it's an order of magnitude, yeah. We did do a good deal of coordination with the EC. We used to share information. We both had cases against IBM, and John Ferry, who was the director of the DG competition, and I used to talk not infrequently about our two cases, but the degree of cooperation and communication today is again far greater than it was in 1969, or 1976 for that matter.
Or 1995 for that matter.
Probably.
Exactly. Well, Bruce, thank you very much. This has been a delight, and I hope you've enjoyed it as much as I have.
I have, Don. Thanks very much.
Thank you.